Again. Okay. So yeah, welcome everybody. We are again lucky to be having Jason Klimek and Elise Bergio to be our guides through the MRTA as we explore part 3 of the MRT workshop. Yeah, it's been so great to having people in the audience through and through these past few workshops. Be sure to drop your comments in the chat and be sure to ask questions through the Q&A. I'm not sure if the chat is accessible to everyone, but a lot of people are directing their chat comments directly to us. But if you're able to, I welcome you to address panelists and attendees. If that's not something, please let me know and I'll work on getting that available, because sometimes the conversation we have amidst ourselves is as valuable as the ones that we have with our experts. As I'm getting the back end set up for today's presentation, Elise and Jason, you guys want to give a quick overview and we'll get going from there.
Elise, go ahead.
Well, so actually, before we get going on the overview, actually yesterday, Zach, Jason, and I just recorded a pod on the podcast, The Cannabis Counselor, which is Barclay Damon is the firm I'm at, is the sponsor of it. And we talk about issues kind of outside of what we're talking about here, which is the MRTA. We do talk about it briefly. Jason and Zach make some great points about the distribution licenses, which we talked about last week. But we also, tune in about Delta 8 concentrations, CBD, what life will look like in a post-adult use in terms of hemp space operation that we're currently seeing, and kind of bring some good topics. But they're quick episodes, no more than 20 minutes. So if you're looking for a little bit more of single issue topics in a shorter listening frame, head over to the Cannabis Counselor.
Yeah, drop that in the chat for us too and send it to panelists and attendees. I think that'd be great.
Deal.
Cool. And Jason, you want to introduce yourself or say what's up?
I'm Jason Klimek with Boiling Code, head of cannabis practice. If you haven't been tuning in lately. We'll be talking specifically today about taxes, which is like my big deal that I really nerd out on. So, be prepared to have an exciting afternoon.
Yeah, just to be clear, Jason's going to speak off from memorization. He's going to read through the entire section 20C just because that's how much he loves it. So,
yeah, love it. And yeah, you should check out the podcast. It was super fun yesterday.
Yeah, it was. Cool. All right, I'm going to start.
Go ahead. It's basically just this, but
cool.
Different way.
Yeah. Okay, sweet. Here we go. All right, so where we left off, we finished licenses last week. If you weren't here, message us directly. We can send you the recording if you weren't there. But we're starting on section 76 of Article 4, which is adult use. And this begins to lay out kind of the specifications outlining, underlying, and surrounding the licenses that we just reviewed. So we're going to cover this part first, and then we're going to dive into taxation. So I will pick it up to start. And if folks aren't familiar with this process, we kind of do round robin. Everyone takes a little swing at doing some reading. And you'll see in some certain sections, I have stuff highlighted just from my own personal use. It helps kind of exemplify key sentences and paragraphs. And then, just in case you're wondering why some things are in yellow. All right, so notification to municipalities of adult use retail dispenser or on-site consumption license. Not less than 30 days nor more than 270 days before filing an application for licensure as an adult use retail dispensary or RO adult use cultivation processor distributor retail dispensary or an on-site consumption license, an applicant shall notify the municipality which the premises is located of such applicant's intent to file for such an application. So again, no less than 30 days and no more than 270 days before. You got to let your community know that you're planning on opening a consumption lounge or a retail space. Such notification shall be made to the clerk of the village, town, or city as the case may be, wherein the premise is located for the purpose of this section. A, notification need only be given to the clerk of the village when the premise is located within the boundaries of the village. And B, in the city of New York, the community board established pursuant to this section 2800 of the New York City Charter, with jurisdiction over the area in which the premises is located shall be considered the appropriate public body to which notification shall be given. 3, such notification shall be made in such form as shall be prescribed by the rules of the board. So the board's going to tell us how we got to communicate our proposal. When a city, town, or village and in New York City, a community board expresses an opinion for or against the granting of such registration, license, or permit application, any such option shall be deemed part of the record upon which the official makes its recommendation to the board to grant or deny the application, and the board shall respond in writing to such city, town, village, or community board with an explanation of how such an opinion was considered in the granting of denial or of an application. So I do think this is a big thing. Last time we talked a little bit about, environmental impact statement as an example, and the process that if you want to build a new house or you want to build something somewhere, all the steps that need to go is in presenting to the community, having in some cases impact statements and or getting feedback from community members, or in this case, the board, where that information will be captured within your application process, submitted to the state, it sounds like, and the state has to respond to those concerns if they say yes or no, regardless. So it does seem like there's a lot of kind of back and forth there, but it does sound like there will be a pretty intimate kind of correspondence between city public officials and the board.
And I think it's also reinforcing that kind of policy behind the MRTA of we want the community involvement. We want you to show what you're going to do for the community. So you got to have the community, organization, the board, the trustees, whatever, on board with you so that they, their opinion is expressed to the cannabis, Office of Cannabis Management. And so I think that's, really important, and it's just showing you how the state wants you to work all the way down to the local levels to really show how you're going to benefit the community and further the policy goals.
Yep. Yeah, that's good feedback there. As we continue, section 5 says, such notification shall be made, A, by certified mail, return receipt requested, B, overnight delivery service with proof of mailing, or C, professional or personal service upon the offices of the clerk or community board. The board shall require such notification be on a standardized form that can be obtained on the internet or from the board, and such notification to include the trade name or doing business as name, if any, of the establishment, B, the full name of the applicant, C, the street address of the establishment, including the floor location or room number, if applicable, D, the mailing address of the establishment, if different than the street name, E, the name, address, telephone number of the returnee or representative of the applicant, if any. F, the statement indicating whether the application is what the application is for, whether the application is for a new establishment, a transfer of existing license, a renewal of existing license, or an alteration to an existing license. G, if the establishment is a transfer of previously licensed premises, the name of the old establishment and such establishment's registration or license number. In the case of renewal or alteration, the registration or application number of the applicant and the type of license. So just if there's any changes, like, it kind of seems like previous history has to be included in that expression if you're transferring a license. Jason, you want to take adult use on-site consumption?
Sure. So let's see. Adult use on-site consumption license, provision governing on-site consumption licenses. No applicant shall be granted an adult use on-site consumption license for any premise unless the applicant shall be the owner thereof or shall be in possession of said premises under a lease in writing for a term not less than the license period. However, that such license may thereafter be renewed without the requirement of a lease as provided in this section. This subdivision shall not apply to premises leased from government agencies, provided, however, that the appropriate administrator of such government agency provides some form of written documentation regarding the terms of the occupancy which the applicant is leasing said premises from the government agency for presentation to the office at the time of the license application. Such documentation shall include the terms of occupancy between the applicant and the government agency, including but not limited to any short-term leasing agreements or written occupancy agreements. So remember, 2 weeks ago now, where we talked about you had to have the possession or control of it, but if you were social equity, they give you that window. So we're still seeing, like, maybe you have to commit to having a place before you actually get authorization licensing. So I would imagine those types of issues are going to be worked out in regulation. Number 2, no person may have a direct or indirect financial or controlling interest in more than 3 adult use on-site consumption licenses issued pursuant to this chapter. Also recall that each site apparently gets its own license. So that's just saying that you can't have more than 3 adult use on-site consumption sites. No person holding an adult use on-site consumption license may also hold an adult use retail dispensary, cultivation, processor, micro business, cooperative, or distributor license pursuant to this article, or be registered as a registered organization pursuant to Article 3 of this chapter.
So I actually got a question pretty recently, which I think is applicable here, on whether or not, because the requirements are that you need to really have 3 real estate locations at the time of your application, which is, a pretty excessive burden, right? For those who might be, not a multi-state operator, or, for somebody who's just trying to enter into the industry, but might want to have 3 stores eventually, on whether or not they're going to be able to do so, or they think that you'll have to apply for 3 at once, and then you'll get awarded 3, but there might not be another open, because they might cap licenses. You might not be able to get your other 2 down the line. I think that's a really interesting topic, which I've kind of been saying, hey, if you have the means to do so, apply for all 3 with the anticipation that hopefully you'll get them. But they might just be approving you for 1 out of 3 too, at the time that it starts. So, when you're thinking about your strategy for entering into the industry, real estate really needs to be an important topic for you. And if you want to stay in Rochester, if you want to do Rochester, Potsdam, and, and near the city, that's something that you should be doing now as we wait for these bills to pass, because it's gonna take a little bit to figure that logistically out.
Mm-hmm. I definitely would recommend, you start having conversations and things like that. Just the one caveat there is we still don't know what the opt-outs are going to look like. So, if we end up with the CRTA, which I do think is the least likely of the 2 now, given certain recent events, as we more discussed on Elisa's podcast, if we were to end up with that opt-out provision, you could have your heart set on a town in a county that decides to opt out, even though the town was totally cool with it. And now you're stuck. So, it's really hard when you have these 2 very different opt-out provisions to even do, you can plan, but to commit yourself, there's a big risk there. So it's difficult, the government's not making it easy. All right. So number 4, no applicant shall be granted an adult use on-site consumption license for any premises within 500 feet of school grounds, as such term is defined in the education law. So I think we discussed this last time too, that had included houses of worship. That has since been removed. No explanation.
Which seems like a New York City play, right? Because, houses of worship could be anywhere. Like they could be in an apartment in the city. It's a little bit more of that's a stricter regulation down there where it's so close. 500 feet is just, there's so much that happens in 500 feet.
Yeah. And it's interesting too, that was both the MRTA and CRTA. All right. The board may consider any or all of the following in determining whether public convenience and advantage of the public interest will be promoted by the granting of the adult use on-site consumption license at a particular location.
Yeah, that one's just so strange. It's like, obviously, like your opportunity to show advantage in public convenience. Okay, is it walkable? Things like that. That's something to consider. But then public advantage of like, in a world that's anti-cannabis, like what's the advantage in the public interest? Like I do see that's going to be a curious thing. Whereas advantage could be jobs, it could be accessibility. There's a list of things that could be there, but it is just that kind of like the board decides on whether this is right or wrong.
Well, and I would say one thing too that it would be like a safe space, so that you're giving people a place to consume, as opposed to they're in the park or in other public spaces, things like that. So you gotta sometimes be a little creative.
Mhm.
what a lot of these application writings are going to be, is, really telling a narrative story.
Totally. Mike, just to answer your question, well, your question will be answered in a moment. But yes, you do own a dispensary license. You cannot own an adult use as it is defined here. However, as a consuming on-site consumption facility, we're going to see in a moment that distribution is able to happen there under specific parameters.
All right. So let's see. I just read. The board may consider all the following. Okay. That it is a privilege and not a right to cultivate, process, distribute, and sell cannabis. The number, classes, and character of other licenses in proximity to the location and in particular municipality or subdivision thereof. Evidence that all necessary licenses and permits have been obtained from the state and other governing bodies. Whether there is a demonstrated need for spaces to consume cannabis, the effect of granting a license on pedestrian or vehicular traffic and parking in proximity to the location.
So I think that's interesting. Sorry to interrupt. I think that's interesting, right? Because in my head, strategy talking, I'm like, oh, I want to put an on-site consumption lounge right next to a dispensary, right? Like I might not be the owner of that dispensary if I'm the on-site consumption license holder, but in my head, I'm like, oh, that makes the most sense. Like putting, well, it's not really like that, but I was going to say like putting a liquor store next to a bar, I guess doesn't really, like putting a dispensary next to an on-site consumption lounge would make a lot of sense. But they're saying that they might limit the proximity of the location with other licenses. So that's something that, when we have comment periods, we want to make sure that that's for rules and regulations, that's super vetted out, because strategy really will come down to that when you're looking at real estate.
I think it begs the question too, like, is it a place where you're trying to sell product, on-site consumption for special events, or is it a place where people can BYOC, bring your own cannabis? And I think that's a big question. And yeah, Mike, I see your comments of frustration. I think one thing that's interesting is I don't know personally of any other states that have on-site consumption connected to a dispensary.
Correct.
Maybe old school Colorado back in like 2010. We were able to rip bong at the dispensary if no one was there, kind of thing. But besides that, I don't know too many places where that's been like the standard.
Even on-site consumption lounges are still, pretty scarce in adult use states. So I think even having this license is a big forward step in the process.
Corey asked a question, does it specifically call out liquor licenses and the potential proximity limitation? I don't know if we've seen that yet, but maybe that's...
I don't think it does. They do say, though, you can't co-locate. That's the only thing that we've seen on that issue, but not like proximity where it's similar to the 500 feet of a school ground. So,
but I could also imagine that a local board or something may take that into consideration. If you have bar, dispensary, bar, on-site consumption, but maybe they're like, we need to kind of ease up a little bit. Somebody doesn't need to be able to walk within 50 feet and just get absolutely annihilated. Who knows? That this is really kind of coming down to like the moral governance of the board. Like there's legal limitations of what they can and can't do, but at the end of the day, it's really going to be like the opinion of the board members. So it's hard to kind of prognosticate what that'll be.
So just like for an example, right? For those who are listening from like Buffalo and are familiar with like Allentown. Allentown is like our big hub of bars in like the area, but they all have to get approved by the board to be there. And the board is brutal, okay, to get like a new bar up and running. That's what I foresee happening a lot, especially when you're in big populated going out areas like Chippewa. I mean, like I'm not as familiar with Rochester, but like Chippewa, all that stuff, like there's separate approval process when you're co-locating that closely to other recreational booze and things like that.
There's another question just in this thread from Mike. So setting up a management company, can you manage both a dispensary and a lounge, but not have a controlling interest? In the past few workshops, we've seen the language be so explicit that you may have no interest.
No indirect, yeah.
No indirect, direct, and that's a big thing.
And in talking with somebody yesterday, an interesting point came up on that is, what if a parent owns one license and a child owns another license? I mean, it wouldn't take, a really experienced lawyer to make the argument that that's an indirect interest at the very least. But is that something where the government can say, well, your parent's doing it, so you're forbidden from doing it? That doesn't seem like the right answer.
Yeah, and there was the
Right.
like, controlling interest of like a minor child, but nothing specifically outlining an adult child. So that may be some kind of loophole. Well, you didn't say that. You say here that a child that's like, a younger child, an adolescent child, a minor or whatever, can't have any equity, but doesn't say anything about a 40-year-old child. So I do wonder how those loopholes will be approached.
So I think in terms of the assessment, when we talk about like controlling interest, like that is going to be this, if you read these bills, that is probably half the bill in totality about controlling interest and like only being able to have this license or this license and this license. And I mean, I would just say err on the side of caution with trying to pull one over on their heads, because when you think about the process for like WMBE businesses, they vet you pretty heavily. They look at your operating agreements. They take a really good dive onto like the controlling interest, who the investors are. And so, I would just be reluctant, if you truly want to get into the industry, I'd be reluctant to pull the wool. I'm not saying people might be not success, they might be successful and do it, but I don't think that's going to be the standard.
Yeah, New York is pretty notorious for really digging in through their agencies. If you've ever dealt with the New York State Department of Tax, they are ruthless as compared to like the IRS. And it's a lot, New York is very against trying to game the system, at least for us common folks. Maybe if you have billions of dollars, a little different.
So where do we leave off there?
I think we are at F. The existing noise level at the location, and any increase in noise level that would be generated by the proposed premises, and any other factors specified by law or regulation that are relevant to determine the granting of license would promote public convenience and advantage and the public interest of the community. If the board shall disapprove of an application for an on-site consumption license, it shall state and file in its offices the reasons therefor and shall notify the applicant thereof. Such applicant may thereupon apply to the board for a review of such action in a manner to be prescribed by the rules of the board. So there is an appeals process. No adult use cannabis on-site consumption licensee shall keep upon the licensed premises any adult use cannabis products except those purchased from a licensed distributor, adult use cooperative, or micro business authorized to sell adult use cannabis, and only in containers approved by the board. Such containers shall have fixed thereto such labels as may be required by the rules of the board. No adult use on-site consumption license shall reuse, refill, tamper with, adulterate, dilute, or fortify the contents of any container of cannabis product as received from the manufacturer or distributor. No adult use on-site consumption license shall sell, deliver, or give away, or cause, or permit, or procure to be sold, delivered, or given away any cannabis for consumption on the premises where sold in a container or package containing a quantity or number of servings more than than authorized by the board. So they're setting it up so that they can do very small amount or some amount as prescribed.
Yeah, like maybe you can buy one edible, but you can't buy a 10-pack of edibles,
Basically, these
maybe you
places
can
are
buy
not going to be
gram, but you can't buy an ounce.
right. These are not going to be substituting for dispensaries.
Mm-hmm.
Let's see. No adult use on-site consumption licensees shall suffer, permit, or promote activities or events on its premises wherein any person shall use the premises for activities including but not limited to gambling, exposing or simulating contests or fireworks that are prohibited by subdivision blah 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 of the alcoholic beverage control law, or any other similar activities the board deems prohibited. So they could come out and say, you can't promote bar or liquor or alcohol. Like we don't know yet, because they're going to probably do this through license or through regulation, maybe even just guidance. All right,
Guys, correct me if I'm wrong. Is there an event permit in here? I mean, we'll probably get to it, but do they have the permit sections like they do in the CRTA? We'll have to get to it, because I'm just thinking, I mean, like,
is it in general provisions? Is there something explicitly as an event? I don't remember, but we will get there, folks.
we will get there. I'm just thinking because the CRTA, and maybe they don't have permits because they do have a nursery license and some of the stuff that were permits under the CRTA. But this is interesting because what would be curious is if they do have or the reason I say that is if you have an event permit, that means that if you have an on-site consumption lounge, you can then also lease out your space to all these people who have event permits, which is another nice way of generating revenue if you don't want to necessarily be the one putting on the cafe or the event of that day.
Mm-hmm. Yeah, I like that.
But don't quote me on that yet until we know if there's a
Nah, here we go.
caveat.
Number 10. No premises licensed to sell adult use cannabis for on-site consumption under this chapter shall be permitted to have any opening or means of entrance or passageway for persons or things between licensed premises and any other room or place in the building containing the licensed premises or any adjoining or abutting premises, unless ingress and egress is restricted by an employee, agent of the licensee, or other method approved by the board of controlling access to the facility. So if you're located next to a dispensary, you can't have a door to go into one another unless it's monitored by an employee. But essentially, you'd have to go in, buy it at the dispensary, go out, and then into on-site consumption lounge. Each adult use on-site consumption licensee shall keep and maintain upon the licensed premises adequate records of all transactions involving the business transacted by such licensee, which shall show the amount of cannabis products in an applicable measurement purchased by such licensee, together with the names, license numbers, and places of business of the persons from whom the same were purchased, the amount involved in such purchases, as well as the sale of cannabis products made by such licensee. The board is hereby authorized to promulgate rules and regulations permitting an on-site licensee operating 2 or more premises separately licensed to sell cannabis products for on-site consumption to inaugurate or retain in this state methods or practices of centralized accounting, bookkeeping, control, records, reporting, billing, invoicing, or payment respecting purchases, sales, or deliveries of cannabis products, or methods and practices of centralized receipt, storage of cannabis products within the state without segregation or earmarking for any such separately licensed premises, wherever such methods and practices assure the availability at such licensees' central or main office in this state or of data reasonably needed for the enforcement of this chapter. Such records shall be available for the inspection by an authorized representative of the board. Basically, if you have more than one, you can have like one main office. That's all that's pretty much saying. All licensed adult use on-site consumption premises shall be subject to inspection by any peace officer acting pursuant to his or special duties, or police officer, and by the duly authorized representative of the board during the hours when the said premises are open for transaction of business. An adult use on-site consumption licensee shall not provide cannabis products to any person under the age of 21. They're not permitted. It's the same thing as a bar. You're not permitted on the premises if you're under 21. The provisions of this article, public health law restricting smoking and vaping of cannabis, shall not apply to adult use on-site consumption. So they are allowing the smoking of cannabis in these facilities, despite the general ban on smoking indoors in New York. Do you want me to keep going?
Lisa, you want to take record keeping and tracking?
Sure. Okay, record keeping and tracking. The board shall by regulation require each licensee to adopt and maintain security tracking, record keeping, record retention, surveillance systems relating to all cannabis at every stage of acquiring throughout, every license, manufacture, sale, delivery, transporting, testing, distributing, subject to regs. So every licensee shall keep and maintain upon the licensed premises, books and records of all transactions involving the licensee. Sale products, basically just keep your records for at least 5 years, basically. Each sale shall be recorded separately, a numbered invoice, which shall have printed thereon the number of the licensee, the address of the licensed premises, and the current license number. Licensed producer shall deliver to licensed distributor a true duplicate invoice stating the name of the purchaser, the quantity, the description, and the price of the product, and make sure it's a true and accurate statement for terms of sale made. Such books and records and invoices shall be kept for 5 years and shall be available for inspection by any authorized representative of the board. Each adult use and registered organization, adult use cannabis dispensary, microbiz, on-site consumption, shall keep and maintain upon the licensed premises adequate records and transactions for each business and license, shall show the amount of cannabis and weight purchased by a license together with the name, license plates, and places of business and persons for whom were purchased, The amount in such purchases as well should be the sale of cannabis license. So guys, this seems like a lot, but there's going to be a seed to sale tracking system that's going to make this a little bit more of a seamless process. So a lot of this is just in the computer. You know, when somebody comes in, they put in you get their license, you put that information in, and then once they have bought the product, it kind of goes into that system. Oregon was using Metric, but I don't think we know what system can be used yet. Each adult use RO, adult use cannabis, retail dispensary, microbusiness, onsite consumption license, shall keep and maintain upon the licensed premise. Oh wait, I already said that, sorry. Inspections and ongoing requirements. All licensed or permitted premises, regardless of the type of premise, shall be subject to inspection by the office, by the duly authorized reps of the board, by any peace officer acting pursuant to his or her special duties. That could be a police officer during the hours when the said premises are open for the transaction of the business. The board shall make reasonable accommodations so that ordinary business is not interrupted. Person who holds a license or permit may make him or himself an agent available and present for any inspections. You don't have to be there. Such an inspection may include, but is not limited to, ensuring compliance by the licensee or permittee. So basically just, they're gonna let you know if they're having an inspection, make sure that you're available or an agent of your business is available to be there at the time of the inspection. Adult use cultivators, processors, or distributors not to be interested in retail dispensaries. Again, this is a big component that we keep talking about. No vertical integration for non-micro businesses or ROs. Shall be unlawful for a cultivator, processor, co-op, or distributor license under this Article 2. Be interested directly or indirectly in any premises where any cannabis product is sold at retail, or in any business devoted wholly to partially to the sale of any cannabis product at retail by stock ownership, interlocking directors, mortgage or lien, or any personal or real property, or by any other means. By any other means is a real big catch-all. So, you know, even if it's not listed here, they might be using something else that'll come up. Make or cause to be made any loan to any person engaged in the manufacture or sale of any cannabis product or wholesale at wholesale or retail. Make any gift or render any service of any kind whatsoever directly or indirectly to any licensed person on this chapter, which in the judgment of the board may influence such licensee to purchase the product of such cultivator and processor or distributor. So that's interesting, right? So
Yeah, that could be your issue there, Zach, of like you hold one license but work for somebody else.
Yep. Or, I mean, I don't know, like, does that include too, like, if you are, yeah, I think the next one kind of thinks where my head's at. If you're a cultivator and you're like, hey, everyone go check out this dispensary, even though it's not yours, which I think is kind of what we're getting into D, which is enter into any contract with any retail licensee whereby such licensee agrees to confine his or her sales, well, to cannabis products manufactured sold by one or such cultivator or processors or distributors. Any contract shall be void and subject the licensees of all parties concerned to revocation for cause. I think that you're going to have, there's going to be some scrutiny on showing favoritism to other licensees as a holder.
Which also makes interesting too, like that probably will facilitate more inspections of books and records because they're going to want to see, are you getting sweetheart deals from certain suppliers or something like that? Like it's going to, I think that right there is going to increase compliance a lot, like your compliance costs, I would say.
Okay, I think we're down a little bit more, Zach.
Oh, sorry. Are we passed?
Yeah, we're on page 45 now. Yep.
Yep.
The provisions of this section shall not prohibit a registered organization authorized pursuant to section 3968A or 68B of this section from cultivating, processing, or selling adult use cannabis under this article at facilities wholly owned and operated by such RO, subject to the conditions, limitations, and restrictions. The board shall develop rules and regs in regard to this section and in consultation with the State Cannabis Advisory Board. So let's get into quick packaging and labeling of adult use cannabis products. The board is hereby authorized to promulgate rules and regulations governing the advertising, branding, marketing, packaging, and labeling of cannabis products sold or possessed for sale in New York State, including rules pertaining to the accuracy of the information and rules restricting marketing and advertising to youth. Such regs shall include, but not limited to, packaging must meet the requirements similar to that of Poison Prevention Packaging Act of 1970. There should be separate packaging for, separate packaging for each serving for each cannabis infused product. Prior to delivery or sale of retailer cannabis and cannabis products shall be labeled and placed in a resealable child-resistant package. Packages and labels shall not be made attractive to minors, which again is in like coloring, it's in the name, all things you got to think about.
One thing that just jumps out at me is all cannabis infused products shall have a separate packaging for each serving. So does that mean gummies come in blister packs? Because that's how that reads.
It kind of feels like, yeah, the gum, you know, when you pop out, like you got to pop out a gum, or like, or
Interesting,
yeah,
because the
like,
ROs currently don't do that.
Yeah, true.
That is true. I kind of was almost thinking like, are people going to loophole it, right? And say the serving is the package.
Serving is 1,000 milligrams. Enjoy.
Hey, one question that just popped up from Tim is, if someone has another interest in another state, that's a question I've also had. Like, what if someone does own another business in a different state? Is that an interest, and does that impact how you operate in New York State?
So long as you're not invested in a multi-state operator under one holding company that's gonna be getting, I think, and correct me if I'm wrong, Jason, like say you're an investor in a multi-state operator that's in like Oregon and California and Colorado, they use one holding company name. They don't differentiate it between like, you know, X Industries New York, X Industries Colorado, X Industries California, and you're invested in that holding company and they're applying for the New York license, I would say is the one thing you'd have to worry about. But most companies don't split it up that way because of taxation issues and just with it being a Schedule I substance. So most companies do break it down LLCs per state. But you'd have to be careful, I think, just of a holding company you're invested in as opposed to a state operation.
Yeah, basically just trace it up like the corporate structure. And if you go up from your ownership and then you can go back down to another New York license, you're gonna have an issue if you have a separate license on your own.
Mm-hmm. But if that company isn't entering into the state you're in, I wouldn't have any issues.
Yeah, there's nothing in the bill that suggests out-of-state operators can't also operate in New York. You know, if you own a fully vertically integrated in Colorado, there's nothing saying you can't be, you know, a processor or a dispensary, one or the other in New York.
Yep.
Great.
Okay. Prior to delivery or sale at retailer, cannabis and cannabis products shall be labeled, placed in resealable child-resistant package. Packages and labels shall not be attracted to minors. Such regs shall not require labels warning customers or consumers of any potential impact of human health resulting from the consumption of cannabis products that shall be affixed to those products when sold, if such labels are deemed warranted by the board. Such rules and regs shall establish methods and procedures for determining serving size for cannabis-infused products and active cannabis concentrations per serving size. So such regs shall also require a nutritional fact panel that incorporates data regarding serving size and potency thereof. There are some stuff in this bill that needs to match up with what they just put in the hemp extraction bill. I think that there is some differences between their labeling requirements for hemp.
Yeah, because if you're under supplemental, you can't put nutritional.
Right.
That pulls you back.
They have to match up. Also, this bill hasn't really been changed in 2 years. I don't think. Maybe last year they just done the latest revision as C, but definitely not since the hemp regulations have happened. So there may be some changes in that respect in terms of mirroring them up, especially on this labeling and packaging side. Zach, you want to take over again?
Yep. So we are on laboratory testing. Every processor of adult use cannabis shall contract with an independent laboratory permitted pursuant to section 129 of this chapter to test the cannabis products it produces pursuant to the rules and regulations prescribed by the office. The board may assign an approved testing laboratory which the processor of adult use cannabis must use. I actually think that's an interesting one right there. So right now it's generally pretty free for all in the hemp industry, but the board may assign you a specific testing laboratory that you must use. That's interesting to me. Let me see. So adult use cannabis processors shall make laboratory test reports available to licensed distributors and retail dispensaries for all cannabis products manufactured by the processor. Licensed retail dispensary shall maintain accurate documentation of laboratory test reports for each cannabis product offered for the sale to cannabis consumers. Such documentation shall be made publicly available by the licensed retail dispensary. On-site laboratory testing by licensee is permissible. However, such testing shall not be certified by the board and does not exempt the licensee from requirements of quality assurance testing at testing laboratory pursuant to this section. Again, you can do testing in-house, but you got to your credited testing report, your COAs, et cetera, is going to have to be a third party. An owner of a cannabis laboratory testing permit shall not hold a license in any other category within this article and shall not own or have ownership interest in an RO registered pursuant to Article 3 of this chapter. The board shall have the authority and to require any licensee under this article to submit cannabis or cannabis products to one or more independent laboratories for testing. All right, provisions governing the cultivation and processing of adult use cannabis. No cultivator or processor of adult use cannabis shall sell or agree to sell or deliver in the state any cannabis products, as the case may be, except in originally sealed containers containing quantities in accordance with the size standards pursuant to the rules adopted by the board. Such containers shall have affixed thereto such labels as may be required by the rules of the board. No cultivator or processor of adult use cannabis shall furnish or cause to be furnished to any license, any exterior or interior sign printed, painted, electric, or otherwise, except as authorized by the board. The board shall make such rules as it deems necessary to carry out the purpose and intent of this subdivision. So basically, there's local zoning when it comes to signs, et cetera, but also the board's going to determine what you can use for promotion from a sign perspective. Cultivators of adult use cannabis shall comply with the plant cultivation regulations, standards, and guidelines consistent with the provisions applicable to hemp, cannabinoid hemp, and hemp extract, and issued by the board in consultation with the Department of Environmental Conservation and the Department of Agriculture and Markets. Such regulations, standards, and guidelines shall be guided by sustainable farming principle practices, such as organic, regenerative, and integrated pest management models, and shall restrict wherever possible the use of pesticides to those that are registered by the Department of Environmental Conservation or that specifically meet the United States Environmental Protection Agency registration exemption criteria for minimal risk, used in compliance with the rules, regulations, standards, and guidelines issued by the Department of Environmental Conservation for pesticides. No cultivator or processor of adult use cannabis, including an adult use cannabis cooperative or microbusiness, may offer any incentive, payment, or other benefit to a licensed cannabis distributor or retail dispensary in return for carrying the cultivator, processor, cooperative, or microbusiness products or preferential shelf placement. So no given deals, it sounds like. All cannabis products shall be processed in accordance with the GMP processes pursuant to Part 111 of Title 21 of the Code of Federal Regulations, as may be modified by the board. So that's an important one to just, that's again, this whole GMP certification, that's the mandate for the hemp industry right now, hemp processors. And that's that's one to highlight. I'll do that when I'm here. No processor of adult use cannabis shall produce any product which in the discretion of the board is designed to appeal to anyone under the age of 21. The use of or integration of alcohol or nicotine in cannabis products is strictly prohibited. So no selling blunts and no selling your Green Dragon beverage. Jason, can you take over for this next section? I got to grab my outlet or my charger.
Sure. All right. Provisions governing the distribution of adult use cannabis. No distributor shall sell or agree to sell or deliver any cannabis products, as the case may be, in any container except in a sealed package. Such container shall have affixed thereto such labels as may be required by the rules of the board. No distributor shall deliver any cannabis products except in vehicles owned and operated by such distributor or hired and operated by such distributor from a trucking or transportation company registered with the board, and shall only make deliveries at licensed premises of the purchaser. Each distributor, Zach, if you're there, can you move it up? Each distributor shall keep and maintain upon the licensed premises adequate books and records of all transactions involving the business transacted by such distributor, which shall show the amount of cannabis products purchased by a distributor together with the names, license numbers, and places of business from where it was purchased. Keep records.
Yeah, I know. I feel like a lot of this is going to just be a lot of copy paste of what we saw for the retail.
Yeah.
Hey, before we get too far from it, I do want to. Corey has an interesting question about allowances. Does this section seem like there be I don't know what depiction allowances allowed, volume by discounts? So like differing levels of pricing for the same product based on volume. I do think that's an interesting question because it says like preferential treatment or whatever, but like if someone's buying bulk, obviously you can give them discount prices.
That's probably, my guess is that's probably going to be okay as long as it's for everybody. You buy, an ounce at a time, it's this. You buy a pound at a time, it's that. And I don't care who you are, that's the price. That's probably okay. That would be my guess. All right. No distributor shall furnish or cause to be furnished any licensee, any exterior or interior signage, unless authorized by the board. I think that is important just to point out, they say licensee. So like a cultivator couldn't give a dispensary a, cardboard sign or something like that to put up unless it was authorized by the board. No distributor shall provide any discount or rebate or customer loyalty program to any licensed retailer except as otherwise allowed by the board. The board is authorized to promulgate regulations establishing a maximum margin for which a distributor may mark up a cannabis product for sale to dispensaries. Any adult use cannabis product sold by a distributor for more than the maximum markup allowed shall be unlawful. That'll be a point to remember when we get to the taxation piece, because that's actually really important.
I can pick back up if you want, or you can keep going.
Sure, go ahead.
Provisions governing adult use cannabis retail dispensaries. No cannabis retail licensee shall sell, deliver, or give away, or cause, or permit, or procure to be sold, delivered, or given away any cannabis to any persons actually or apparently under the age of 21 years old, visibly intoxicated, or impaired.
So, like bars, dram shop laws. That's going to be difficult with cannabis. I feel like. I think that's pretty vague.
Yeah. Valid proof of age is required at each transaction. No licensee or agent or employee of such licensee shall accept as written evidence of age by any person for the purchase of any cannabis or cannabis product, any documentation other than a valid driver's license or non-driver identification card issued by the Commissioner of Motor Vehicles of the federal government and the United States territory, Commonwealth, or possession, the District of Columbia, a state government within the United States, or a provincial government of the Dominion of Canada, or B, a valid passport issued by the United States government or any other country, or C, an identification card by the Armed Forces of the United States. Upon presentation of such driver's license or non-driver identification card issued by a government entity, such licensee or agent or employee thereof may perform a transaction scan as a precondition to the sale. So they may
if you've ever bought alcohol.
Yeah.
Same thing.
Yep. Precondition to the sale of cannabis product. Nothing in this section shall prohibit a licensee or agent or employee from performing such transaction scan on any of the documents listed in the subdivision if such documents include a barcode or magnetic strip that may be scanned by a device capable of deciphering any electronic readable format. In instances where the information deciphered by the transaction scan fails to match the information printed on the driver's license or non-driver identification card presented by the cardholder, or if the transaction scan indicates that the information is false or fraudulent, the attempted purchase of the cannabis or cannabis product shall be denied. No cannabis retail licensees shall sell alcoholic beverages, nor have or possess a license to sell alcoholic beverages on the same premise where cannabis products are sold. No sign of any kind, printed, painted, or electric, advertising any brand shall be permitted on the exterior or interior of such premise except by permission of the board. That's an interesting one. So if you have you walk in to your beer shop and they have a sign that's promoting beer of the month. Like, you got to get that permitted through the board, which is interesting. Let me see. There was a question that came in the Q&A. Does number 4 pertain only to the brands whose products are available, or the dispensary brand itself? Seems open to interpretation. I interpret it as the products, but yeah, it does seem a little bit open to interpretation. What do you guys think?
I agree.
I mean, I think that they're prohibiting all signs unless authorized, and that's my reading of it is, and that would be my advice. Is unless you get permission, probably don't push the envelope.
I don't think that they're going to be approving every single signage. I think a lot of that's going to come down to local. Like, I think you'll have to submit probably your labels like they do with everything else.
Mm-hmm.
You have to show your labeling and things like that, but I don't know. I mean, I can't imagine that they're going to be looking at any kind printed, painted, or electric advertising, any brand.
I mean, I would think that they're probably going to come out with a standard. This is what is acceptable. Anything outside of that, you need our approval.
Agreed.
So that'll probably be the reality.
Yep.
Whoever put most towns have town ordinances, or most towns have sign ordinances. That's right. Yeah.
Yep.
You're going to need to have that approved. You might be able to get something approved by the board, but your locality is going to say, no, take that down.
Yeah. So number 5, no cannabis retail licensee shall sell or deliver any cannabis products to any person without knowledge of or responsible cause to believe that the person to whom such cannabis product is being sold has acquired the same for the purpose of selling or giving them away in violation of the provisions of this chapter, or violation with the rules and regulations of this board. So is that just saying, like, you can't sell it if you know someone's going to give it away?
It's preventing diversion to the illicit market.
Yeah, got it. All premises licensed under this section shall be subject to inspection by any peace officer described in subdivision 4 of section 2.1 of the criminal procedure law, acting pursuant to his or her special duties, or a police officer or a duly authorized representative of the board during the hours in which said premises is open for transactional business. No cannabis retailer licensee shall be interested directly or indirectly in any cultivator, processor, distributor, or microbusiness operation pursuant to this article by stock ownership, interlocking directors, mortgage, or lien on any personal or real property, or by any other means. Any lien, mortgage, or other interest or estate, however, now held by such retailer on or in the personal or real property of such manufacturer or distributor, which mortgage, lien, interest, or estate was required on or before December 31st, 2019, shall not be included within the provisions of this subdivision, provided, however, the burden of establishment at the time of the accrual of the interest comprehended by the subdivision shall be upon the person who claimed to be entitled to the protection and exemption founded hereby. I think that might be a place where, we're looking at an older version of the bill. And is the updated version bill say 2020? Does it say 2021? That's a question I would have.
Probably.
Mm-hmm.
No cannabis retailer licensee shall make or cause to be made any loan to any person engaged in the cultivation, processing, or distribution of the cannabis pursuant to this article. Each cannabis retail license shall designate the pricing of each item of cannabis by attaching to or otherwise displaying immediately adjacent to each of such item displayed in the interior of the licensed premises, whereas the sale are made, a price tag, sign, or placard setting forth the price at which such item is offered for sale therein. No person's licensed to sell cannabis products at retail shall allow or permit any gambling or offer any gambling on the licensed premises, or allow for illicit drug activity on the licensed premises. 11, if an employee of an adult use cannabis retail licensee suspects that a cannabis consumer may be abusing cannabis, such an employee shall encourage such cannabis consumer to seek help from substance use disorder program or harm reduction services. The board shall develop standard operating procedures and written materials to be distributed to cannabis retail licensees in consultation with the Office of Addiction Services and Supports for adult use cannabis retail licensee employees to utilize when interacting with or consulting consumers for the purpose of this subdivision. The board is authorized to promulgate regulations governing adult use dispensing facilities, including but not limited to the hours of operation and the location of the licensed facility, potency and types of products offered, and establishing a minimum and maximum margin for retail dispensary markups of cannabis products or products before selling to a cannabis consumer. Any adult use cannabis product sold by a retail dispensary for less than the minimum markup allowed in regulatory shall be unlawful. All right, so anyone want to take on adult use cannabis advertising?
Sure. Hold on. Adult use cannabis advertising. The board shall create rules and regs governing the advertising marketing of a licensed cannabis and cannabis products or services. So there's going to be explicit rules prohibiting advertising that is false, deceptive, misleading, promotes overconsumption, depicts consumption by children or minors, is designed in any way to appeal to children or other minors, is within 500 feet perimeter of here we go, school grounds, playground, childcare providers, public park, or library. Keep those in mind. Is in public transit vehicles and stations, is in the form of unsolicited internet pop-ups, is on publicly owned or operated property, makes medical claims or promotes adult use cannabis for medical or wellness purposes. And that's only for adult use cannabis. The board shall create explicit rules prohibiting all marketing strategies and implementation, including but not limited to branding, packaging, labeling, location of cannabis retailers, and advertisements that are designed to appeal to people less than 21, provide false or misleading information to consumers. All advertisements and marketing accurately and legibly identify the licensee or other business responsible for its content. Any broadcast, cable, radio, print, and digital communication advertisements only be placed where the audience is reasonably expected to be 21 years of age or older, as determined by reliable, up-to-date audience composition data. So social and
only advertise on the oldies station.
Right, exactly. Social and economic equity, minority and women-owned businesses, disadvantaged farmers, and service-disabled veterans incubator program. The board, in consultation with the state advisory board and the chief equity officer, and after receiving public input, shall create and implement a social and economic equity plan and actively promote applicants from communities disproportionately impacted by cannabis prohibition, and promote racial, ethnic, and gender diversity when issuing licenses for adult use cannabis related activities, including mentoring potential applicants by prioritizing consideration of applications by applicants who are from communities disproportionately impacted by the enforcement of cannabis prohibition or who qualify as a minority or women-owned business, farmers, or service-disabled veterans. Such qualifications shall be determined by the board in consultation with the state advisory board and the chief equity officer. The board's social and economic equity plan shall promote diversity in commerce, ownership, and employment, and the opportunities for social and economic equity in the adult use cannabis space. This shall be established to award 50% of adult use cannabis licenses to social and economic equity applicants and ensure inclusion of. Woo! I just read that number for the first time. 50%. If you're one of those 5 categories, that means that there's going to be a massive influx of social equity applicants.
Mm-hmm.
Individuals, here's how you fall under a social equity applicant. You're either an individual from a community who's been disproportionately impacted by the enforcement of cannabis prohibition, which I'm not sure they have defined.
Probably going to be based off the zip code is my guess.
I agree. A minority-owned business, a women-owned business, which again, does that mean that they have to be certified by New York State to be a women-owned or minority-owned business? That's important.
I don't think they can, because in order to be certified, you have to be in business for a year. So I think the language is that you have to be able to qualify for.
As one, yep. Disadvantaged farmers as defined in subdivision 5 of this section. Again, that's something we're going to think about when we think of hemp operators. Will they fall under disadvantaged farmers? Disabled service disabled veterans. So those are the 6. Yeah, 6 categories. The social and economic equity plan shall require the consideration of additional criteria in its licensing determinations under the social and economic equity plan. and they'll be given extra priority to the applications that demonstrate that as an applicant. If they're a member of a community disproportionately impacted by the enforcement of cannabis prohibition, that'll bump your application up. If you have an income lower than 80% of the median income of the county in which an applicant resides, was convicted of a marijuana related offense prior to the effective date of this chapter, was convicted of a marijuana related offense, or had a parent, guardian, child, spouse, or dependent. The board, in consultation with the Cannabis Advisory Board and the Chief Equity Officer, shall also create an incubator program to encourage social and economic equity applicants to apply, and if granted an adult use cannabis license, permit, or registration. The program shall provide direct support in form of counseling services, education, small business coaching, and financial planning compliance assistance. For purposes of this section, the following definitions shall apply. Minority-owned business shall mean a business enterprise, including a sole proprietorship, partnership, limited liability company, or corporation that, so these are big ones, guys, at least 51% owned by one or more minority members. So that means that if you have 3 partners, right, and 2 are minority and 1 isn't, and they have more than 51%, you're qualifying as social equity. An enterprise in which such minority ownership is real, substantial, and continuing. So continuing is a big one, right? You can't just be, you apply with a minority in the application, and then a year later that ownership interest is purchased by a non-minority. They'll be looking at that. They'll be looking heavily at that. An enterprise in which such minority ownership has and exercises the authority to control independently the day-to-day business decisions of the enterprise. Again, we're talking about decision-making. That's why I think the operating agreements and the acts are definitely going to be looked at, because that's all in their corporate formation documentation.
Yeah, and at the end of the day, I mean, the social equity applicant has to have absolute control. They can determine the flow of the company, the course of the company, everything like that. That's a requirement.
This, to be honest with you, if you guys are applying to as a social equity applicant, this is the most important section of the whole thing. An enterprise authorized to do business in the state and independently owned and operated, an enterprise that is a small business. Minority group members shall mean a U.S. citizen or permanent resident alien who is and can demonstrate membership in one of the following groups. Okay, here's who's qualifying as minority, okay? Black persons having origins in any of the Black African racial groups. Hispanic persons of Mexican, Puerto Rican, Dominican, Cuban, Central, or South American of either Indian or Hispanic origin, regardless of race. Native American or Alaskan Native persons having origins in any of the original peoples of North America. Asian and Pacific Islander persons having origins in any of the Far East countries, Southeast Asia, the Indian subcontinent, or the Pacific Islands, which I think is a pretty big encompassing one. This is the same under the CRTA, but I mean, if you're Indian, if you're Asian, you may fall under minority as well. It's not just Black and Latino. Women-owned businesses shall mean any business enterprise, including a sole proprietorship, partnership, LLC, or corporation that is at least 51% owned by one or more U.S. citizens or aliens who are, or resident aliens who are women. An enterprise in which the ownership interest of such women is real, substantial, and continuing. An enterprise in which women ownership has and exercise the authority to control independently day-to-day decision-making. An enterprise authorized to do business in the state and independently owned and operated. An enterprise that is a small business. A firm owned by a minority group member who is also a woman may be defined as a minority-owned business or a women-owned business, or both. I would highlight that, Zach.
Yep. That's
really giving preferential treatment to all my diverse ladies over here. Love to see it. Disadvantaged farmer shall mean a New York State resident or business enterprise, including a sole proprietorship, partnership, limited liability company, or corp that has reported at least 2/3 of its federal gross income as income from farming. Interesting. In at least one of the 5 preceding tax years, and who farms in a country that has greater than 10% rate of poverty, or I'm sorry, in a county, 10% rate of poverty according to the latest U.S. Census has been disproportionately impacted by low commodity prices or faces the loss of farmland through development of suburban sprawl. That's an interesting one. Meets any other qualifications as defined in regulation by the board. So I think that third point is going to be where they would make a specific point on hemp, as opposed to trying to like do a workaround on these other two.
And I would point out too that those are in the conjunctive, meaning you have to hit every single one of those things, not just one of them, to be a disadvantaged farmer.
Correct. Yep.
There is a comment in the, and I just want to see if we can get an update from Outreach New York Small Pharma. So they lobbied to get the or we were told we're successful. I'm not sure how to interpret that.
Me neither. Does that mean that there's an and or on the disadvantaged farmer? Saying
And change to or.
So they only have to be one of those.
So we'll have to see if there's whenever they
change the bill.
Yeah.
Cool. But yeah, that's interesting. Another example of how working with legislators can get bills changed. Thank you, Small Pharma, for updating us there.
Love to see it.
I do want to say, it looks like we'll be able to finish this adult use section, but I think we're going to have to add probably another workshop specifically looking just at taxes. So we actually have another Tuesday in the month of March. We'll send out a message where maybe we do next week is the taxes, and we kind of push everything back just a week, but we'll confirm after. I just want to address that. We mentioned we'd be going to adult use taxes, but we've been diving pretty deep in here, so we'll pick up taxes next week. But take it away again, Elise.
Okay, so service disabled veterans shall mean persons qualified under Article 17B of the executive law. Communities disproportionately impacted, here we go, shall mean but not be limited to a history of arrests, convictions, and other law enforcement practices in a certain geographic area, such as but not limited to precincts, zip codes, neighborhoods, and political subdivisions, reflecting the enforcement of cannabis prohibition during a certain time period. When compared to the rest of the state, the board shall, in consult with the state cannabis advisory board and the chief equity officer, issue guidelines to determine how to assess which communities have been disproportionately impacted and how to assess if someone is a member of that community. The board shall actively promote applicants that foster racial, ethnic, and gender diversity in their workforce. So it's not going to be a requirement, but for those who are applying to social equity applicants and you want to beef up your application, you have to put out employment plans of how you're going to basically be giving back to these communities who've been disproportionately impacted or in these racial, ethnic, and gender capacities. Licenses issued under the social and economic equity plan shall not be transferred or sold within the first 3 years of issue, except to a qualified social and economic equity applicant and with prior written approval of the board. So you can only sell your license to another social equity applicant, and that can only be done after 3 years of having the license. In the event a social and economic equity applicant seeks to transfer a seller license at any point after issue, and the transferee is to a person or entity that does not qualify as social and economic equity applicant, the transfer agreement shall require the new license holder to pay to the board any outstanding amount owed by the transfer to the board as repayment of any loan issued by the board, as well as any other fee or assessment as determined by the board. So that's interesting. So if you're a social equity applicant and you were getting like your licenses waived, your fees waived, your application fees waived, maybe you got a zero interest loan or a small interest loan. If you do sell, it sounds like you are able to sell to somebody who's not a social equity applicant, but they have to do a back pay of everything that you were given to you as priority as a social equity applicant.
Yeah, for the first 3 years, you're restricted to only transferring to social equity applicants. After 3 years, you can do it to anybody, but they'd have to repay any kind of loans or anything. And to point out, the CRTA says 2 years, so there's a year difference.
Shall not be transferred. Okay.
All right, we're
After the issue. Okay. Are you sure it's after the, I mean, the language is saying at any point after issue. So the issue, I don't know if it's after those 3 years.
License issued under social shall not be
We're just
transferred
that last
forward.
line on 51. In the event of social and economic equity applicant seeks to transfer or sell their license at any point after issue. It might be during. Yeah, highlight that because I don't know. I'm reading that as it's not after the 3 years.
What
Because
is
that you can sell to somebody who's not social equity.
I think you can because it says shall not be transferred or sold in the first 3 years of issue, except to a qualified social and economic equity applicant with the prior written approval of the board. So then, in the event,
But then the next line contradicts it because in the event a social and economic equity applicant seeks to transfer or sell their license at any point after issue, and the transferee is to a person or entity, it's not saying 3 years after issue like it is in the first line.
yeah, but I think that's just saying that if you ever try to sell this to a non-social equity applicant, they have to pay back the board, but you can only sell it to a non-equity applicant after 3 years. That's how I read it, and I'm pretty sure that's what somebody.
They got to clean up that language.
Yeah.
They just got to put after 3 years in that line. As written, it's ambiguous.
All right, we got some, there's been a bunch of chat in the chat, which I appreciate. Some things we haven't addressed, but I appreciate perspectives such as Dennis. You know, your input's been really interesting to follow. And I think there's definitely a lot to consider back to best management practices of when it comes to all the pesticides use, et cetera. It's just always interesting to kind of see different people's perspective as we're looking at this. Let's roll out and finish maybe 2 cents, Jason and Elise, on the last question we have in the Q&A before we wrap up. Again, folks, we will come back with an adjusted schedule to emphasize a focus just on adult use taxation. We don't want Jason to feel left out because he has so much to share, and we know how excited he was. So the question that we're going to take off with from Sheldon Roberts, off topic, and hopefully you can answer this at the end, but what are your thoughts on the current state of legalization? Cuomo has a lot of distractions going on right now. Any thoughts of the best or worst case scenario on timing legalization?
I still think budget, but I'm leaning more towards the MRTA, or at least something that more closely resembles the MRTA than the CRTA. That's my feeling.
I think by budget, we're going to know if Cuomo's resigning. And then it's a different scenario because, I mean, I think still MRTA is the priority right now because Cuomo's lost all of his leverage that he had as kind of a stronghold for the CRTA to get into the budget.
Mm-hmm.
But session goes till June. So like, I mean, I haven't seen the MRTA move from the finance committee yet. Last I looked, it's still in the finance committee. And it needs to switch over to the floor to be voted on in the assembly and then in the Senate. And so, I mean, that process hasn't even happened yet. We're in almost, close to the middle of March. I mean, the next couple of weeks are really going to be a crapshoot on what happens. But the nice thing is we're in a different point that we were in, last year, 2 years ago. There is a supermajority of Democrats in the legislature. And so for so long, everyone's been saying that the MRTA cannot be a standalone bill. Well, I think that it absolutely can. Mm-hmm. The only thing that'll end up happening, I think, after the budget is, so say the budget happens and the CRTA is not included in it. Well, then if that happens, we have only to go off of after April, the MRTA getting voted on in the legislature during session. And so that is, you just get a little bit more nervous that they're going to solidify that by the end of the session.
And it's important to understand just the procedural. All the legislature can do in terms of the budget is make suggestions or strike an entire portion. They couldn't, for example, take out the CRTA, put in the MRTA, or even change the language in the CRTA. They can just say to Cuomo, we want you to change this. But their only remedy at the end of the day, if Cuomo doesn't agree, is to pull it out of the budget, at which point, that's when what Elise just said would come into play is they're voting on it, passing it as a standalone, and then perhaps pressuring Cuomo to either pass it or they'll override his veto with their supermajorities.
So right now there's a line in the budget. I think it's 30 million for the OCM. I could be wrong. I thought that's what I read.
And there was an interesting comment from small pharmas saying they have to include some aspects in the budget or it won't happen because they have to fund the OCM.
Yep. So OCM, the budget line for the OCM has to still be there, which I think at this point they put in 30 million for the OCM in the budget. But the budget isn't the same as the legislation put in the budget. Those are two different things. So they could still fund OCM with
Office of Cannabis Management.
Yeah, Office of Cannabis Management. But again, that you only really are doing that if you're confirmed that that's happening before you put the money in. So like, I mean, I don't know. I just personally think like, I don't know why the legislator is taking so long. Like, let's get this MRTA voted on the floor.
I remember, I think it was 2 years ago when I was talking to somebody and it was like the third week of March and I was like, oh, we're getting pretty close. And they're like, oh, that's cute. This is an eternity for the budget. They literally are working until the wee hours of April 1st on the budget. So, you know, I do expect like we might start to see a clearer picture, but there can be substantial changes that happen even in the last few hours. It's apparently a very crazy process in Albany.
Crazy, 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 folks.
So sorry for DMP. So OCM is a new agency under the State Liquor Authority. So it'll be under SLA, but it is a newly created, I guess you can call it a bureau. It's they're calling it the Office of Cannabis Management.
And it'll pull medical away from the Department of Health. It'll pull and cannabis extracts, and it'll pull hemp cultivation from Department of Ag and put it all under one regulatory agency, which is great because having it under three agencies, two of which it's not their primary focus, really has produced a very difficult regulatory scheme.
Org chart is, who knows how that org chart's going to be because it's all kind of independent, right? I mean, you have the executive director and you have the board, you have adult use, and then you have medical, and then you have hemp. So they're going to have to appoint a lot more directors, I think, for all across the board because like we don't even really have a director of medical cannabis right now, I don't think.
OCM will have its own enforcement too. That's provided in the bill, is that
which is important, right? Because that's why Department of Ag has just dropped the ball on enforcing anything, is because they don't have any enforcement powers. So like when people are getting all pissed off at people who are, selling CBG illegally and like white labeling completely illicit products, everyone's like, who do we go to?
And they could, as your comment said, they could have badges and guns. The post office has its own police. The IRS has special agents with badges and guns. I mean, yes, they could. I don't know if they will, but regulatory agencies can. And they, as Elise said, they do need enforcement because people then just flaunt the laws and it's a problem. Yeah. Especially if you're competing in a regulated industry. You want to be competing on the same ground as everybody else. You don't want somebody breaking the laws with nothing happening.
I will also say this, the police are very reluctant to make big, well, I mean, they'll make big seizures, but they're having difficulties identifying the difference between hemp and marijuana already. And they're not going to go guns blazing into a place unless they're confident, because they're just getting trolled on the internet. And you guys have probably seen when these cops come out, they're like, we confiscate 200 pounds of marijuana, and then it's tested and it's hemp, and they're like, it's mortifying. So it's, a little bit of a different situation, I think.
They are allocating funding for law enforcement training, specifically DREs, drug recognition experts. So that should hopefully help a little bit. But at the end of the day, I defy anybody to look at a bud from hemp and a bud from THC cannabis and tell me which is which without, trying it and telling me what happens, or without a COA, because that's it. That's the only way you're going to see it.
Great. All right, folks, we got to wrap up this week's session. Again, look for the follow-up. Anyone who is still on, you'll get a recording of this. We dug deep. It was fun to see those little definitions pulled out at the end that aren't included in the initial definition section, which is just interesting. But yeah, we'll be sharing this, and you'll hear from us about kind of some updates regarding schedule, because we definitely want to dive into taxes. That's a crucial next step. And again, thanks to all of our sponsoring members and individuals, as well as Harris Beach Law Firm for supporting us through and through. Big thanks to Elise and Jason for your endless, consideration for the community at large, and just your wisdom in this section that's just ever evolving. So we appreciate you guys' time so much.
Wow,
Absolutely.
I can't possibly live up to that.
We'll see you all soon.